Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Gang Enhancement Lawyer, Chicago, Illinois. Facing a gang enhancement charge in Chicago, Illinois can significantly raise the stakes of an already serious criminal allegation. These enhancements can add substantial prison time and harsher penalties to an underlying offense, putting your freedom and future at even greater risk. If you've been accused of a gang-related crime or had a gang enhancement added to your charges, it's critical to act quickly. At Combs Waterkotte, our criminal defense attorneys have decades of experience handling complex felony cases throughout Illinois. We understand how gang enhancements are charged and what it takes to challenge them. If you're ready to fight back, call 3-125-00-HELP today to begin building a strong defense and protect your future. Gang Enhancement Lawyer in Chicago, serving all of Cook County, Illinois. Gang enhancement allegations in Cook County are often built on complex evidence, including alleged affiliations, communications, and patterns of behavior that may be open to interpretation. In many cases, these enhancements are added to increase leverage against the accused, making it even more important to have a defense team that knows how to push back effectively. At Combs Waterkotte, we take a proactive approach to defending clients facing gang enhancements in the Chicago area. Our attorneys dig into the details, challenging how the enhancement was applied, examining whether your rights were violated, and identifying flaws in the prosecution's narrative. With over 80 years of combined experience and robust resources throughout Chicago and all of Illinois, we know how to navigate high-stakes felony cases and pursue outcomes that protect your record, your freedom, and your future. If you're facing gang enhancement charges in Cook County, don't wait to get the legal support you need. Contact Combs Waterkotte online or call 3-125-00-HELP today to start building your defense. What are gang enhancements in Chicago, Illinois? Under Illinois law, gang enhancements to criminal charges are complex and varied. Understanding them starts with understanding how the state of Illinois defines gang-related terms. The Illinois Street Gang Terrorism Omnibus Prevention Act lays out the following definitions. Street gang or gang: an organized alliance, network, or group of 3 or more people who engage in a pattern of criminal activity. Street gang member or gang member: someone who is a member of a gang and participates in illegal activity for that gang. Pattern of criminal activity: 2 or more criminal offenses committed in Illinois in whole or in part when both offenses were committed within 5 years of each other, and at least one offense involved an attempt or commission of a felony or forcible felony. The Illinois Criminal Code allows judges to impose a more severe sentence when a defendant is convicted of an offense related to gang activity. These are called gang enhancements, and they're permitted under 730 ILCS 5/5-5-3.2. These gang enhancements take standard felony prison terms and extend them. Class X felony prison sentences are enhanced from 6 to 30 years to 30 to 60 years. Class 1 felony prison sentences are enhanced from 4 to 15 years to 15 to 30 years. Class 2 felony prison sentences are enhanced from 3 to 7 years to 7 to 14 years. Class 3 felony prison sentences are enhanced from 2 to 5 years to 5 to 10 years. Class 4 felony prison sentences are enhanced from 1 to 3 years to 3 to 6 years. Gang enhancements may essentially be added to any felony charge and are often imposed for crimes like homicide, assault, and theft. But there are certain offenses that have gang-related sentencing enhancements written into the criminal statutes themselves. Common criminal charges with gang enhancements in Chicago, Illinois. Many criminal offenses in Chicago and Cook County, Illinois, have gang enhancements written into their statutes. These extended prison sentences are common in gang cases involving drugs, weapons, theft, and violence. Below are some of the gang enhancements our firm helps defend against most often. Street gang criminal drug conspiracy enhancements in Chicago. Illinois' manufacture or delivery of a controlled substance law, 720 ILCS 570/401, covers sentencing for particular amounts of certain controlled substances in great detail. But the street gang criminal drug conspiracy law, 720 ILCS 570/405.2, outlines increased sentences for the manufacture or sale of controlled substances as part of gang activity. The statute calls for extended prison sentences for gang members who deal heroin, fentanyl, cocaine, morphine, peyote, and other illegal drugs. Here are the standard sentences and the increased gang-related sentences depending on drug weight: 1 to 14 grams. Standard sentence: 4 to 15 years. Gang-enhanced sentence: 10 to 30 years. 15 to 99 grams. Standard sentence: 6 to 30 years. Gang-enhanced sentence: 5 to 60 years. 100 to 399 grams. Standard sentence: 9 to 40 years. Gang-enhanced sentence: 15 to 60 years. 400 to 899 grams. Standard sentence: 12 to 50 years. Gang-enhanced sentence: 15 to 60 years. 900 grams or more. Standard sentence: 15 to 60 years. Gang-enhanced sentence: 15 to 60 years. It's also important to know that the street gang criminal drug conspiracy law carries the potential for major fines, up to $500,000. Illinois' Drug Asset Forfeiture Procedure Act also allows law enforcement to seize any property or assets gained as a result of gang-related drug dealing. Unlawful possession of a firearm by a street gang member enhancements in Chicago. Illinois' unlawful use of a weapon statute, 720 I, LCS 5/24-1, outlines several penalties for individuals who possess certain banned weapons or who carry weapons in certain locations. The law's base charge is a Class A misdemeanor, but the charge may be elevated to a Class 4 felony for carrying a gun in a bar or public event, or when wearing a mask, a Class 3 felony for having a silencer, a short-barrel rifle, or an explosive, a Class 2 felony for having a machine gun, a Class X felony for having a loaded, accessible machine gun in a vehicle. Unlawful possession of a firearm by a street gang member, 720 ILCS 5/24-1.8, specifically covers enhancements for weapons crimes committed by individuals involved in gang activity. This offense takes place when the individual is a street gang member. They possess a firearm without a valid firearm owner's ID, FOID card. They possess the firearm in a public place or in a vehicle. Gang members in possession of a firearm without a valid FOID card automatically face a Class 2 felony charge with a prison sentence between 3 and 10 years. Merely possessing the weapon is enough. It does not need to be used in a crime. If the weapon is loaded, the offender must serve a minimum of 3 years in prison. Identity theft and aggravated identity. Theft gang enhancements in Chicago. 720 ILCS 5/16-30 covers identity theft crimes in Illinois. The law outlines certain prison sentences for certain value thresholds of money stolen. When identity theft is committed by a gang member on behalf of their gang, some of these prison sentences increase. Amount stolen: less than $300. Standard sentence: Class 4 felony. Gang enhanced sentence: Class 3 felony. Amount stolen: $300 to $1,999. Standard sentence: Class 3 felony. Gang enhanced sentence: Class 2 felony. Amount stolen: $2,000 to $9,999. Standard sentence: Class 2 felony. Gang enhanced sentence: Class 2 felony. Amount stolen: $10,000 to $99,999. Standard sentence: Class 1 felony. Gang enhanced sentence: Class 1 felony. Amount stolen: $100,000 or more. Standard sentence: Class X felony. Gang enhanced sentence: Class X felony. The law is written in a way that targets enhancements for gang members who steal low and medium-level amounts. The statute also covers other instances where street gang members may face increased penalties. Committing identity theft against 3 or more victims within 1 year is a Class 1 felony. A second or subsequent identity theft offense is a Class X felony. Armed violence gang enhancements in Chicago. Illinois Statute 720 ILCS 5/33. A-2 defines armed violence. Under the law, committing any felony while armed with a dangerous weapon is armed violence. The penalty for a violation depends on the category of the weapon the offender used and how they used it. Committing armed violence with a Category 1 weapon, a handgun, a sawed-off shotgun, or a sawed-off rifle, is a Class X felony with a 15-year minimum prison sentence for possession of the weapon, a 20-year minimum prison sentence for discharging the weapon, a 25-year minimum prison sentence for causing bodily harm or death with the weapon. Committing armed violence with a Category 2 weapon, a rifle, shotgun, knife, dagger, switchblade, or axe, is a Class X felony with a 10-year minimum prison sentence. Committing armed violence with a Category 3 weapon, a bludgeon, blackjack, brass knuckles, or club, is a Class 2 felony with a 3 to 7-year prison sentence. While there are no specific extended prison sentences for gang members convicted of armed violence, 720 ILCS 5/33A-3 says that any gang member found guilty of armed violence and street gang criminal drug conspiracy must serve sentences for both crimes consecutively. In other words, if a gang member receives a 25-year sentence for armed violence and a 35-year sentence for drug conspiracy, they will serve a total of 60 years in prison. Aggravated intimidation gang enhancements in Chicago. Under 720 ILCS 5/12-6.2, aggravated intimidation is a Class 2 felony when an individual intimidates a police officer to prevent them from doing their job. However, the offense is a Class 1 felony when it is committed by a gang member attempting to prevent someone from testifying against their gang and its activities. Obstructing justice gang enhancements in Chicago. The base-level penalty for obstruction of justice is a Class 4 felony under 720 LCS 5/31-4. However, Any street gang member who commits obstruction of justice to further gang-related activities can be charged with an enhanced Class 3 felony. Dogfighting gang enhancements in Chicago. Under 720 ILCS 5/48-1, dogfighting is a Class 4 felony offense. But when a dogfighting ring is run by members of a gang in order to generate profits for that gang, any gang members involved may be charged with a Class 3 felony. Criminal defense strategies for gang enhancement charges in Chicago, Illinois. Criminal defense strategies for gang enhancement charges in Chicago, Illinois. Gang enhancements carry some of the longest possible prison sentences in the Chicago and Cook County area. At Combs Waterkotte, we've defended Chicago clients against gang enhancement charges in the past. The following criminal defense strategies are effective in helping to reduce or dismiss gang enhancement charges in Cook County courts. Challenging gang allegations through lack of intent. For many Chicago gang-enhanced charges, prosecutors must prove the defendant acted in furtherance of gang activity. A defense attorney can argue lack of intent, showing the accused's actions were unrelated to any gang purpose. For example, a person charged after a bar fight or drug sale may have acted independently, not to benefit a gang. By separating the conduct from alleged gang motives, the lawyer can fight to reduce or eliminate the enhanced penalties. Using alibi evidence to refute participation. An alibi defense can be powerful in gang-related prosecutions in Cook County, especially in cases involving shootings, robberies, or coordinated drug transactions. If a defendant can prove they were elsewhere through surveillance footage, phone records, or witness testimony, the prosecution's case can collapse. For example, if someone is accused of participating in a gang-related drive-by shooting but was at work or home at the time, the enhancement and underlying charge may both fail. Arguing coercion or duress in gang contexts. Chicago gang cases often involve allegations that individuals acted voluntarily, but a strong defense may show coercion or duress. A lawyer can present evidence that the defendant was threatened with violence if they refused to participate in a crime, such as delivering drugs or acting as a lookout. In these situations, the defense argues there was no meaningful choice, potentially defeating both the underlying charge and the gang enhancement tied to intentional participation. Challenging illegal searches under the Fourth Amendment. Gang-related cases in Cook County courts frequently rely on evidence obtained during traffic stops, home searches, or surveillance operations. A defense attorney can challenge whether law enforcement violated the Fourth Amendment by conducting an unlawful search or seizure. For instance, if police recover a firearm or drugs without a valid warrant or probable cause, that evidence may be suppressed. Without it, prosecutors may lose the ability to prove both the base offense and any gang-related enhancement. Suppressing due to Miranda rights violations and the Fifth Amendment. In Chicago gang investigations, police often rely on statements made during interrogations. If officers failed to advise a suspect of their Miranda rights or used coercive tactics, those statements may be inadmissible. For example, a confession linking a defendant to a gang-related drug conspiracy could be excluded if obtained improperly. Removing statements made in violation of a defendant's Fifth Amendment rights can significantly weaken the prosecution's case and undermine claims that the defendant acted in furtherance of gang activity. Raising entrapment in undercover operations. Chicago and Cook County police sometimes use informants or undercover officers in gang-related drug and weapons investigations. An entrapment defense argues that the defendant was induced to commit a crime they otherwise would not have committed. For example, if an informant pressures someone into selling drugs or obtaining a firearm to benefit a gang, a defense attorney can argue the criminal conduct originated with law enforcement, not the accused. Asserting self-defense or defense of others. Not every violent act tied to alleged Chicago gang activity is criminal. A defense lawyer may argue self-defense or defense of others when a client is accused of assault, battery, or even homicide. For example, if a person used force during a confrontation, but reasonably believed they or someone else faced imminent harm, the conduct may be justified. This can negate both the underlying charge and the claim that the act furthered gang activity. Applying necessity or claim of right defenses. In some Cook County and Chicago gang-related prosecutions, a defendant's actions may be justified under necessity or claim of right. For instance, a person accused of possessing stolen property or participating in a drug transaction might argue they acted to prevent greater harm, or believed they had a legitimate claim to the property. By reframing the conduct as justified or lawful under the circumstances, a defense attorney can challenge both the criminal charge and any associated gang enhancement. What to do if you're facing gang enhancement charges in Chicago, Illinois? If you've been arrested and are facing a gang-enhanced charge in the Chicago or Cook County area, it's not an exaggeration to say that the things you say and do in the minutes and hours after your arrest can mean the difference between going free and spending decades in prison. At Combs Waterkotte, our expert criminal defense attorneys recommend taking the following steps. Do not speak to police without a lawyer. If you are arrested or questioned in connection with a gang-related offense like drug conspiracy or a weapons charge in Chicago, do not answer questions without legal counsel. Anything you say can be used to support both the underlying charge and a gang enhancement. Politely invoke your Fifth Amendment rights and request an attorney immediately. This is especially critical in cases involving alleged confessions or statements tying you to gang activity. Seek legal representation immediately. Gang enhancement charges significantly increase potential penalties, making early legal intervention critical. An experienced defense attorney can begin investigating the case, preserving evidence, and challenging the prosecution's theory from the outset. Early involvement can mean the difference between reduced charges and facing enhanced penalties. Do not wait to secure counsel after charges are filed. Avoid contact with alleged co-defendants. Gang-related cases like drug distribution rings or coordinated criminal activity often involve multiple defendants. Avoid speaking with anyone connected to the case, even if they are friends or acquaintances. Communications can be monitored and used against you. Even a simple text message could be interpreted as evidence of conspiracy. Let your attorney handle all communication to avoid unintentionally strengthening the prosecution's case. Document any coercion or threats immediately. If you were pressured or threatened into participating in transporting drugs, acting as a lookout, or committing any kind of physical violence, document those circumstances as soon as possible. Write down details, save messages, and identify witnesses. This information can support a coercion or duress defense. In gang-related cases, demonstrating that you acted under threat can be critical to reducing or dismissing charges tied to intentional participation. Challenge unlawful searches and seizures. If Chicago law enforcement recovered drugs, weapons, or other evidence during a stop or search, your attorney may be able to challenge whether it was legally obtained. For example, if police searched your vehicle without probable cause or a valid warrant, the evidence may be suppressed. This is especially important in gang-enhanced cases, where physical evidence is often used to tie defendants to broader criminal activity. Preserve evidence that supports your alibi. If you were not present when an alleged gang-related crime occurred, begin gathering evidence right away. This may include surveillance footage, GPS data, receipts, or witness statements. For example, if you are accused of participating in a gang-related shooting or robbery, proof that you were at work or home can be decisive. Acting quickly ensures that time-sensitive evidence is not lost and can be used effectively by your defense attorney. Be cautious about social media activity. Prosecutors in Chicago and Cook County frequently use social media posts, photos, and messages to argue gang affiliation or intent. Avoid posting anything that could be misinterpreted, including references to groups, symbols, or locations. A photo with certain hand signs or captions, for example, could be used to support a gang enhancement. Your attorney can advise you on how to limit exposure and prevent prosecutors from building a gang involvement narrative around your online activity. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.